Hello, good morning, and welcome to Newsfile. This is your most authoritative news analysis platform. And here on Newsfile, as always, we put Ghana first. This morning, we canvass two very important issues for you. A petition to remove the Special Prosecutor from office. Many ask, is it corruption that is fighting back? Others ask, we are all under the law. The Special Prosecutor, the President, the Chief Justice, whoever they are, Speaker of Parliament, if they err, they must face the music. Professor Stephen Kweku Asare, you know him popularly as Kweku Azan, his summary of what is happening is this: that Martin Amidu is asking for Kissie Jabin to be removed because Kissie Jabin refuses to put the appointment letters and salary details of all staff of the OSP on a pen drive for him by a request, RTI request that Martin Amidu made to the Special Prosecutor. Again, he says that Martin Amidu is saying the Special Prosecutor should be removed from office because he is recruiting staff from sister agencies. Martin Amidu's claim, one of them, is that the Special Prosecutor is inducing staff of sister agencies like IOCO, and he has procured evidence of that. The evidence is that those staff resigned and joined the Special Prosecutor's office. Professor Kweku says Martin Amidu has been maliciously accusing and attacking the Special Prosecutor since day one, just like he did to his successor at the Attorney General's department. And then he cautions, don't dare touch the Special Prosecutor. But why not? We're all under law, as I said earlier. Then the Cedi's dance, the Cedi's behavior or misbehavior, should that rather be the subject that should lead to the removal from office of its managers? How is life treating you in the face of the Cedi rising to almost 15 cedis to $1? I'm Samson Lardy Anyenini. We'll be right back to deal with the vexed matters. Welcome back, and here is Samson's take. Landlords, don't fret. Caretakers cannot take over your property. Today, my take is brief in simply stating the correct position of a gravely misunderstood law, which has been causing fear and panic, especially among citizens who are laboring abroad to buy land and own real property in Ghana. It is a matter that strangely gains traction ever so often. Caretakers of land, and land in law includes any building on the land. Caretakers get wrongly emboldened to make misguided demands of their landlords. In some instances, the wrong notions about their rights move them to hatch wicked plans, including harming and even killing. Yes, they, rather strangely, feel cheated by those who put them in their property. It does not matter that they may have begged to be allowed temporary shelter for themselves and their families. In fact, sometimes the fact that their benefactors may be their source of livelihood is forgotten in their wicked and false sense of entitlement pursuit to dispossess the kindest people of their sweat and toil. The law, indeed, is not an ass. Here is the clarity. The 12-year rule in section 10.1 and 6 of the Limitation Decree 1972 does not say a landlord loses hold of it because they put you, a caretaker, in their property for that long. What it says rather loudly is that if someone put you on the land or in the house, they never lose it as the true owners because, common sense, it is they who put you on it or in it. In other words, you are on the land or in that house with their consent and at their pleasure. The statement that the law is common sense is often true. If they put you there and you turn around to attempt to dispute their ownership, they have every right to evict you, throw you out, go nurse your greed elsewhere. The 12-year rule, or the law of adverse possession, is intended mainly to remove the injustice of you acquiring a land and maybe making expense to develop it, only to be dispossessed even after a long period of 12 years of acts of open, visible, and unchallenged possession. That law is simply that if you slept on your rights for that long, you may not be entertained in a court of law to seek to recover it. But take note that by Section 236 of our new Land Act, sitting on or developing government land for 100 years in whatever circumstances will never make you the owner. It does not matter whether you entered onto it as a squatter or you bought it. In fact, you will be committing the crime of trespass. And whoever sold that public land to you is also looking to be slapped with a fine of 60 to 120,000 Ghana cedis and or 7 to 15 years in jail. Justice Alexander Osei treats this subject beautifully in his book, Essential Themes in Land Law and Customary Law. Don't thank me yet. Join me on my weekly legal clinic, The Law Show, tomorrow at 2 p.m. as I host two great legal minds, Emmanuel Bright Atoko and Veronica Frimpong, to give education on whether courts make orders for demolition of property. And when is such exercise legal? And that will be my take. We'll be right back to get into the vexed matters. The comment we just played to you from the SP. Some say how prophetic, but others say it is just that you don't know what informed it. Perhaps now you know what informed it. So, my guests are seated. Professor Ernest Kofi Abochi is Dean, UPSA Law School, joins us via Zoom. Dr. John Osai Kwapong, Project Director, the Democracy Project, and fellow CDD Ghana, also joins us via Zoom. Amanda Okoko Clinton is Head of Chambers, Clinton Consultancy. She's right here in the studio, together with Alhassan S. Suhini, MP, Tamale North, and Deputy Ranking Member, Lands and Forestry Committee of Parliament. Ladies and gentlemen, thank you so very much for joining us on Newsfile.
Thank you for having me.
Right. So let's begin. And it is now public. The Chief Justice sent a letter to Cedi Jabing, the Special Prosecutor. It's a letter dated the 16th of May, 2024, addressed to the Honorable Cedi Jabing, Office of the Special Prosecutor. And it is titled, Petition by Martin Alamisi Amidu for the removal of Honorable Cedi Jabing from office as Special Prosecutor, pursuant to Section 15 of the Office of the Special Prosecutor Act 2017, Act 959. This is to forward to you a copy of petition dated 30th April 2024, sent to the Office of the President, which was forwarded to the Office of the Honorable Lady Chief Justice on 6 May 2024. Kindly provide your comments to the matters raised to enable the Honorable Chief Justice determine if a prima facie case has been made out. Thank you, and please accept my compliments. That's the Chief Justice, Justice Gertrude Saki Tokono. And now, members of the public are getting to know some aspects of this petition. And it's been summarized, our knowledge has been summarized in this fashion, that Martin Amidu is raising 6 issues. 1, that Cedi Jabing has been encroaching on authority. 2, that he's been inducing staff from sister law enforcement agencies to abandon where they are now and to join his place. 3, abuse of citizens' rights through arrest and detentions. 4, abuse of the judiciary. 5, procurement breaches. And 6, refusal to comply with RTI requests. These are his sins. A bit of a background: encroachment of authority. We understand he's alleging that it is the president who should have appointed staff of the OSP and not the Special Prosecutor Cedi Jabing. And it's alleging that Cedi Jabing encroached the powers of the president when he engaged the services of 3 directors when he did not have a board at the time. He pointed out in many words that he had mainly sought the secondment of staff to his office with the approval of the president when he did not have a board. That is when he, Amidu, was the Special Prosecutor. However, Cedi Jabing did not seek the approval of the president in making the appointments to the OSP. Inducement of staff from sister law enforcement agencies. What we understand in summary is that he's alleging that the current Special Prosecutor recruited staff from sister law enforcement agencies, particularly Economic and Organized Crimes Office, EOCO, and the Ghana Police Service by inducing them with higher salaries and higher ranks. He attached resignation letters he officially obtained from EOCO, which have been marked restricted. And these people are now working with the OSP. He also attached RTI requests he made to the Ghana Police Service for the names and ranks of officers who have resigned to join the OSP. The police did not give the letters though. What they did was that they provided information about their resignations. Abuse of citizens' rights through arrest and detention. We understand his allegations are that Cedi Jabing's handling of cases involving Madam Cecilia Abena Dapa, Professor Frimpong Boateng, Colonel Damois, and Joseph Eduche, both of the Customs Division of the GRA, and Miss Eunice Jacqueline Boa Asomahene, Chief Executive of the La Bianca and a member of the Council of State, amounted to an abuse of the rights of these citizens through the arrests and detentions made by the OSP. And he has on the issue of abuse of the judiciary, we understand his allegation is that Kisei Jabin's media briefing in November 2023, he told the press that there appeared to be a developing trend of rather regressive and dismissive judicial decisions involving cases that the OSP was dealing with. The OSP gave 4 examples of rulings by the court that appear to ignore the law or reason or both. So Martinabi's allegation is that the criticism made by Kisei Jabin is tantamount to abuse of the judiciary. And as you could remember, he had written articles attacking Kisei Jabin and asking that those comments at the press conference amounted to abuse of the judiciary. And that is on his blog. You can all read it, and we have read them before. And finally, procurement breaches. We understand his allegation is that the SP breached the procurement rules in refurbishment of its new office complex and procurement of vehicles. And he gave exhibits of RTI requests he had made to the procurement authority for documents covering such transactions, even though the PPA denied to supply him the information on the basis that he could get it from the SP and not OSP and not from them. He alleges that he also did an RTI request and the OSP did not grant him the information he was seeking. And the information he was seeking was in respect of asking that he should be furnished with the appointment letters and salary details of all staff of the OSP on a pen drive. This OSP denied him. So, let's begin with Professor Kofi Abochi, Dean of the UPSA Law School. What's your sense of what is happening?
Good morning, Samson.
Good morning.
First of all, it's not uncommon to have requests for removal from office made against certain public officers. So in that sense, it is not the first of its kind. What is peculiar about it is the fact that you have a predecessor official asking a subsequent official in that same position to be removed. I do not remember that in my memory to have happened. That typically you don't have people who've left off asking their move. There's a level of deference and care that best people tend to have needed. But it's not, in light certain terms of the fact of petitioner and the time to
Professor Abochi, we need to take a full benefit of your scholarship as far as your comments and analysis of this issue is concerned. Unfortunately, your line is not the best. So we have to try and reconnect with you to be sure that your line is good enough.
That's fine.
Okay. So let me come to the studio to Amanda Clinton, who has actually authored an article, very sharp, titled A Slippery Slope If Ghana's Second Special Prosecutor Ever is Removed from Office. What are you saying? What are you telling us? Nobody is above the law.
No,
Not even the president.
Not even the president. But I do think that Mr. Amidu's petition, although well laid out, does not go far enough to justify an investigation or a committee being set up, because I don't think a prima facie case necessarily exists apart from the procurement issue.
You are seeking to do the Chief Justice's work for her.
Well, okay,
She's the one to determine if there's a prima facie case.
Of course, but so perhaps we should help her this morning. For instance, let's look through his grounds and the fact that when you're looking at the Special Prosecution Act 2017, Martin Amidu can be, or the new Special Prosecutor can be removed for absolute misbehavior or incompetence, or conduct that brings or is likely to bring the office of the Special Prosecutor into disrepute or ridicule. And with the grounds laid out by Mr. Amidu, I don't think it is satisfied for a prima facie case, apart from the procurement issue, because his office is supposed to investigate procurement issues. And if he himself has committed that crime and it can be proven, then that is a potential ground for removing him. But for instance, inducing staff from sister law enforcement agencies, I don't think in the context of his office is wrong, because having worked at the Attorney General's Department myself, the drive when I was there to recruit was to recruit new and the best, and foreign, local, and people who were specialized, particularly for the international team. And this is an effort of the Special Prosecutor, who was head of chambers or a member of chambers before, to recruit at the highest level. And at the highest level, you recruit those with knowledge from Yoko and different places. So making efforts such as that in order to ensure convictions cannot be a ground for impeachment at all. I don't think Amidu's grounds stand apart from the issue of procurement, potentially.
In such new offices, often they do what you call secondments.
Yes.
So you go to a sister organization and you look for the experts there and you ask them to be brought to your office. Do you get the impression this is different? That's not what is happening.
Yes, I mean, he's recruiting at the highest level in terms of directors, et cetera, because the whole point is the Office of the Special Prosecution is supposed to prosecute cases. It doesn't matter which party you're in, but it is supposed to be seen as acting because that is their function. So should the Chief Justice set up this committee, they will have to go and look into what is the function of the Special Prosecutor. And can this rather be said that he is pushing the agenda of the Office of the Special Prosecution by recruiting at the highest levels? So I think that, for me, having read the petition, it is not strong enough, apart from the procurement issue, that if his job is to go after those who are committing procurement infractions within government in particular, and he himself has done that and it can be proven, then perhaps you can impeach him. But it's a very slippery slope. He's the only second special prosecutor. This is not examples of we've seen him receive monies as part of his job, etc. These are glaring examples.
As a lawyer, you know that criticism of the judiciary, as the Supreme Court itself has said once, however rambunctious, is not contempt of court. But we all must make sure that when we criticize the judiciary, we are tempered and measured.
Yes.
For someone at the highest office of the Special Prosecutor to take judges on the manner he's accused of having done, are you saying that is okay and that should not amount to abuse of the judiciary and to amount to a ground to remove you from office?
I honestly had to go and visit the November 2023 video where the Special Prosecutor had a press conference in which he criticized judiciary, I also went online and read the entire transcript of what he had said, and I was surprised that it was actually quite measured, in my humble opinion, because I agree with the Special Prosecutor that our judges do not consider themselves above criticism. And in that video, for instance, he mentioned an example of how a Supreme Court justice gently chided him in open court for not publishing enough articles criticizing their work. And I honestly believe the fact that he cited 4 examples, it was almost an academic
examples of cases that his office was involved in.
Yes, of cases that he was involved in, where it showed glaring examples of individuals' supposed immunity from being investigated and prosecuted, and the entire function of his office is to do that. And had he, for instance, made the remarks about the judiciary personal, or just the wording, I mean, to tell you the truth, the wording was quite measured to me because it was in the context of actual cases.
He may not be doing this in his private capacity as a private practitioner.
Yes.
But you know the ethics of our profession.
Yes, I do know.
The rules are clear that if you are involved in a case, you don't comment on the case.
Yes, but he did wait until after certain decisions should be made in terms of injunctions, for instance. And he highlighted the fact that the Office of the Special Prosecutor prioritizes transparency in anti-corruption efforts by issuing media releases after major judicial pronouncements or decisions. And these releases inform the public about the OSP's position on whether the opinion advances the fight against corruption or not. And honestly, I really expected the video to be like over the top and just accusing the judiciary, etc. I've never seen such a measured video in terms of even just reading the transcript afterwards. He cited specific examples of how their work was frustrated.
You haven't read...
I read it. It's actually...
Martin Amidu's, no, you haven't read Martin Amidu's criticism of that. When you say this was measured, Martin says this was over the top. He crossed the red line. He ought to have been whipped into submission that very moment, because that's unimaginable. You don't do that.
Yes, but again, I don't think our judges are above... because, for instance, if a judge happened to listen to these submissions that he made, and I would actually invite our High Court judges to listen to the Special Prosecutor's submissions, and I think Daily Graphic published the entire thing verbatim for their assistance as well, you would actually see what he's getting at is you have set up our independent office in terms of the Act, set up their office to go after corrupt officials, etc. That's their entire function. So they should be exempted. And so when you're dealing with particularly powerful people who have large amounts of cash under their bed, etc., and have means of disposing of that cash, when you're fighting white-collared crime, in particular, the movement of cash in bank accounts and under beds, etc., is so fast that you need a judiciary that even overnight can do an injunction and can block it and can preserve the cash until a final court decision, etc. And so he, in a measured tone, cited examples, clear examples, of how a judicial decision had been made, but he does not believe those decisions support his office, and then he cited why. And for me, I think it is a slippery slope to remove him based on such an academic assessment of our judiciary. But if you're going to remove
the judiciary was very unhappy.
Yes.
In fact, there was a summoning of a meeting where he had to attend. We understood that he attended on his own terms. The constitution of even the group, the panel, where he was to go and meet there were certain individuals that there were questions about the caliber or the class of people, you know, who were being brought into a meeting with him that was like he was being taken to the slaughter. But he went there and we understood that he was very unequivocal, unapologetic about what he was doing and insisted that perhaps people do not understand the requirements of such a new office, that such a new office should not be subjected to and limited to, you know, some of these, what people feel are regressive, antiquated rules of shut up, keep quiet, if you're an investigator, don't be seen, don't be heard, and all of that.
Yes. I mean, in fairness, I would invite, I think, the judiciary and anybody interested in this to go online and to just Google the Special Prosecutor's video, November 2023, and also online you'll be able to find the full transcript. And in my humble opinion, I honestly believe that it was extremely measured. And it was measured particularly because he cited examples which meant his office was completely frustrated by their function. And if we look at the Office of the Special Prosecution Act 2017, and in particular Section 3, the functions of the office is to investigate and prosecute cases of alleged or suspected corruption and corruption-related offences, to investigate, to recover and manage the proceeds of corruption, and to cooperate and coordinate with competent authorities. And the judiciary goes to the heart of this mandate.
I need you to hold it on there for me. That's Amanda Clinton. Professor Bochi, hoping that his line is clean now. Thank you, Prof.
Good morning, Samson.
Great, that's better. And forgive us for holding you on, because we know that you must move to a very important meeting. Right, so you were saying that, yes, this is not novel, but what?
It is not novel, but I was indicating by way of a general context that what is novel about it, as far as I remember, in fact, I don't think there's precedent of a predecessor in office taking on a successor in office, not by way of the way he was removed, but by way of, or by reason of challenges he has about how the successor is performing the duties of his office. So, you know, that part is novel. That part I can't remember there's precedent too. But it's important in terms of the substantive issues for us to remember by way of foundation that the mandate of the Office of the Special Prosecutor includes a public engagement. And so that public engagement component of his work invariably will involve him doing things that may ordinarily be out of convention. It is not conventional, by way of standard practice, to have a lawyer go to court and then after court have complaints about how the justice was administered, especially not just a lawyer, but a public officer lawyer, so to speak. And therefore, if you look at the petition of the petitioner, he specifically refers to the fact that if it was a DPP, he could have been someone that perhaps dismissed. And that is true, possibly. And the reason is because there are ethical constraints on how we do our work, particularly as lawyers, in reference to the judiciary. However, in the context of the Office of the Special Prosecutor, things are a bit nuanced. And I think it's imperative that we understand it from that nuanced perspective. He has a public engagement aspect of his work. The question of whether or not he has done his work in a manner consistent with what the law expects, as far as the public engagement part is concerned, is an issue that is open to debate. And I'm not going to make any definitive statements because this is a matter that is unfolding, that is about to be investigated, and the processes are still ongoing. So we need to respect that aspect as well and not make statements that may appear to be publicly prejudicial. So my statements are just general and open-ended for educative purposes. And the point I'm making, particularly in this context, is the fact that if you look at the law that establishes the Office of the Special Prosecutor, the law itself is framed around the 1992 Constitution in terms of the similarity of the offense or the circumstances under which the Office of the Special Prosecutor could be impeached. So Article 146 of the Constitution, for example, establishes the framework for impeaching judges. And the words that were used, among others, stated misbehavior or incompetence. The same rendition has been repeated in the law establishing the Office of the Special Special Prosecutor, in which the OSP can be removed on grounds of stated misbehavior or incompetence. Notably, however, both the Constitution and the OSP Act do not define what constitutes stated misbehavior. Incompetence, we can assume that we probably would recognize what incompetence is if we see one. But stated misbehavior presupposes that there are constituent aspects of what can be considered a misbehavior. However, because the two laws do not define it, the Constitution doesn't define it, so we can't make reference to that, and the Act also doesn't define it. It means that the one making a determination by way of the impeachment, the panel making the determination, will have to decide that a particular act meets that threshold of stated misbehavior. The question is whether acts that are considered just professionally objectionable, whether these acts will meet that threshold, or whether you need specific acts that go beyond just professional misbehavior to constitute an act of stated misbehavior. These are things, again, as I indicated, the law hasn't been tested in that respect, in terms of what constitutes stated misbehavior. If a lawyer does something, if a public servant does something in the context of his office, whether that would be an act of stated misbehavior or just any act we find professionally objectionable. So an act that you may find professionally objectionable could be an act of holding a press conference, for example, and complaining about what judges, may have said or done while in the performance of their work. Whether beyond that constitutes an act of stated misbehavior is still one very much in the air, and in my opinion, we haven't defined that and we haven't ascertained that.
Prof, whilst we have you, and one issue that is coming up, debate among lawyers, and I have done an article 146 process before, which led to the removal of Loretta Lamte from Shraj, and I also took up led Kweku Bako to the Supreme Court to seek to challenge the removal of Charlotte Osei, unsuccessfully. But the issue that is coming up now is, first, the CJ writes to Kissie Jabing and say, bring your comment for me to make a prima facie determination. Some lawyers say you don't need Kissie Jabing to provide you anything to do the prima facie determination. And to some extent, if it is a bare allegation without more, it is the respondent that you are asking to try to supply evidence to help someone who may be into fishing. What do you say? They say she should just look in front of on the face of the documents and make a determination rather than asking for a reaction. Well,
the fact that the law doesn't require something doesn't imply that you cannot do it. What you cannot do is what the law expressly forbids. So if the law expressly says you can't do X, then you can't do X. If the law doesn't say you can't do X, it simply means it is not a requirement, but it's a general permission. So if it's a general permission, you can do that. So the point I'm making is, by standard practice, the determination of the membership, any man standing the context of the OSP Act, does not require necessarily the input of the But that non-requirement is not itself a prohibition. And so Chief Justice wants to satisfy himself that my determination of a prima facie having been established is without, because a prima facie case established, one has to satisfy himself or herself in this context that certain minimum elements or features of the offense have been made. And those minimum elements, ingredients of the offense itself, require certain minimum threshold, which is that the one big step would have to satisfy herself that those elements have been made out do not have purified that challenge that principle. So the point I make is to avoid perhaps any left the realm of doubt, even at the final stage. The CJ your students have a question for you, that when you define prima facie to them, they don't understand it in the manner we are seeking to create this precedent for a determination of a prima facie. If you picked the Oxford Law Dictionary, any one of them, it will simply tell you that prima facie means
Whatever it is you are holding, you look on the face of it and make a determination. So why do you need facts from the opposing side to make that determination? That's the question they're asking.
Absolutely. On the face of it simply means on the face of it. But the point I'm making to you is, even on the face of it, there may be statements that challenges your own assumptions and hunches on the basis of what you're reading. I'm trying so hard so we do not complicate this. Do not forget the fact that as you read a document, you are forming hunches, you are forming opinions, you are drawing conclusions, you are making extrapolations, you are making deductions. All these are things that the mind, all these are cycles and processes the mind goes through as you are reading something. On the face of it, constitutes your judgment of what you get or glean from what you read in the document. Now, the point I'm making is, if the law doesn't forbid, it means that one can do it even as a surplusage or as an extra mile. So my understanding, and again, this is me second guessing, the Honorable Lady Chief Justice on this. My understanding is perhaps she just wants to be sure that she doesn't contradict or she doesn't make a determination that some hunches or some judgments or some opinions she may have formed at this stage may themselves be subject to some erroneous conclusions, and therefore she's going the extra mile, even making a determination at the face of it. She's going the extra mile of giving the option to.
So, as someone who is very familiar with this kind of matters, and I remember when Richard Nyama filed his petition to the president, it was forwarded to the Chief Justice Georgina Wood. She also required the Shraj boss to make comments. So it's a precedent. When the one about Charlotte Osei came up and her deputies, they were required to make their views. But this is one aspect that I will lead you a certain way, where I sought to challenge that kind of thing in the Supreme Court. Does it, and for example, in the first one that I did, there were several petitions, but only one petition was deemed to be competent and used. Must it take the respondent, Kissie Jabing, to tell the CJ, who must make a determination of prima facie, that if you look at Section 75 of the Office of the Special Prosecutor Act, general immunity, an authorized officer is personally immune from civil liabilities in the performance of duties under this act if the authorized officer acted in good faith and on reasonable grounds. Remember, they have the powers of police according to the law. So just like judges also, in Article 127, Clause 3, a justice of the Superior Court or any person exercising judicial power shall not be liable to any action or suit for any act or omission by him in the exercise of their judicial power. My question is, if you say they have breached people's rights by arrests, take that against the immunity they enjoy. Should it take Kissie Jabing to tell the CJ that this is my defense, so throw that issue out?
Again, Samson, I can understand the context in which you make your point, because the truth of the matter is, in standard legal practice, a person is called to open his defense only after he's raised an objection against there being no case, and the court has heard the objection, and the court basically has said, there's a case to be answered, open your defense. So I can understand what you're saying. Ordinarily, the respondent or the response is taken only after a preliminary determination that there's a case, go ahead and respond to it. So I can understand that. But again, this is a peculiar strain.
Okay.
You have a petition brought against a public officer, and then you have the Chief Justice as an individual to make determination of whether she thinks that there's enough case made on the basis of which the respondent should open his defense, or he has to open a defense to the petition that has been brought. The point I'm making is the Chief Justice is not forbidden in deciding whether or not to indicate that there's a prima facie case made. she's not forbidden, in my estimation, from hearing the other side before it appears to be an extra mile that she's done. But the law doesn't forbid that being done.
Right.
And we can't put this in the same straitjacket that we put criminal cases in which a defense only has to...
The next issue around that is, will all of this not be resolved if there were constitutional instruments or regulations about how to exercise this kind of power in respect of Article 296? And in a J-Chum versus the Attorney General, this is what Justice Sufai Akufu said. I quote, "However, I wish to express my misgivings and discomfiture arising from the absence of any consequential enactments which regulate the removal of justices of the Superior Courts, and in particular, any detailed rules of procedure for the performance of such an important process as the removal of the Chief Justice of the nation. The provisions of Article 146 sketch out in broad strokes the basic procedures for the commencing and carrying out the process for the removal of justices of the Superior Courts and the Chief Justice. And as inaptly noted by my brother Professor Okran in his concurring opinion hearing, essential details such as the form of the petition have been left out. Also left vague and unclear are other essential matters such as the procedure to be followed by the committee in the performance of its assignment. This is only as may be expected, since the Constitution is not intended to provide details and procedural guidelines, but rather to establish a framework of the fundamental values and standards upon which substantive and procedural legislation may be and are expected to be built for good governance of the Republic. Is making rules. And she said other things, but for want of time, I don't want to go there. The issue about misbehavior, what constitutes it? She spoke about it. The Supreme Court spoke about it at the time. Is this the way to avoid some of these?
No, I mean, I 100% agree with the fact that the detailing of rules always help clarify gray areas, twilight areas, and any prospect of confusion. So that would have been a very good way of resolving this. Indeed, Article 296 clearly spells out the fact that where the exercise of discretionary authority is by a judge, it has to be based on the constitutional instruments, on the basis of which certain details will have to be given and spelled out to avoid all these confusions. So I do fully agree with you on the fact that maybe all these speculations and uncertainties could have been resolved if the matter had been better clarified by way of a constitutional instrument. You mentioned that the judges about what constitutes data, but it still remains an open-ended area, an open-ended situation in which we do not put the constitutive of stated behavior when allegations of it come. And the Constitution itself says in Article 1511 that where anything constitutional, and in this case, because of the harsh situation of it, where any constitutional, the things are supposed to, unless it is very spelled out as penalty. So all points that complicate things, especially when it gets or penalty that should follow an act deemed an act of.
Your line is getting bad again, but I'll try my very final question to you, Prof. Section 15 says that when the president receives the petition, he's supposed to forward it to the Chief Justice within 7 days. So for those of you who are going on with the mischief that the president did it so swiftly and there have been petitions that he has never forwarded, those were under Article 146, where there's no timeline to forward the petition and so on. And presidents have abused it over the period. You send a petition, they won't forward it because the person you want to remove, they don't want the person removed. Now, this one says he should forward it within 7 days. Then the Chief Justice, within 30 days, must make the prima facie determination. And then when the committee is set up, within 14 days, they must bring their recommendations to the Chief Justice, which she will forward to the President, and the President has no discretion in it. He simply has to implement the decision. The question is this one. The person supposed to constitute the committee if a prima facie determination is made. One, a justice of the Supreme Court. Questions are arising. There is the perception already that the judiciary is not happy with the OSP. A justice of the Supreme Court. B, a lawyer of not less than 15 years standing at the bar. And then C, the third person should be a person who has expertise in investigation. The question is, OSP, Iyoko, having problems, theft wars. OSP is investigating the police on police recruitment scams, and there have been bad blood, as we understand, between the OSP's office and the police because they are making this investigation. So if you need a justice of the Supreme Court, then you need a person with expertise in investigation, most likely to come from either the police, Iyoko, or one of these security agencies. What happens to the rule of natural justice?
Okay, so let me deal first of all with the law, and then let me deal with the perception. By the law and by the decision of Ghanaian courts, even where you have issues with the courts will still have to determine it, and the court will have to still constitute it. Remember the decision in Akufo-Addo and Kwashida, in which the matter arose as to whether the Chief Justice could empanel could put together a panel to make a determination in a matter in which the Chief Justice himself has been sued. And the court came to the conclusion that the Chief Justice in performing that mandate was performing an administrative task. It has nothing to do with his office as a judge. And so, that's the law, unfortunately, in the sense that those who have issues against it, we can only express concerns, but you can't, it's the law. The position of the law is it still remains the mandate of the judiciary to put together the administrative incidents of justice. And you cannot complain or you cannot object against it the way it is. So that's the law. But obviously there's a perception part. And that perception part is justice itself also survives on perception. In fact, the saying goes that justice must not only be done, but it must be visibly seen to be done. And so in this case, we clearly cannot also disregard the perceptual aspect of things. The fact that those who are subject to the administration of justice would have their own perceptual view of things. So I would hope and believe that steps will be taken, in empaneling and putting together a body to determine this matter. Steps will be taken to ensure that those perceptual difficulties are dealt with. The various institutions whose mandate and whose operational behavioral tendencies have involved them and the OSP in a conflict situation. All those will have to be taken into account so that perhaps if the OSP has objections, and if he raises objections about the Constitution, perhaps those who have to be given serious hearings and feedback, just so we deal with the perceptual aspect. But as I indicated, the law has stated the constitution of the panel, the law has stated how the empanelment should be done, and those are the law. Nothing can be done about it.
Thank you very much for your time this morning, Professor Kofi Abochi, Dean of the UPSA Law School. Yes, Alassane Suhuyini, what do you make of all of this?
Well, good morning, Samson. Good morning to Amanda and to Prof and to our viewers out there. Samson, I'm not a lawyer, as you well are aware of. I am a communicator. I've done journalism.
You're a maker of the law.
My master's is in development management. And I'm now making the laws in Ghana as a representative of the people of Tamale North, and by the grace of God. So my approach is not going to be legalistic. It's going to be, if you like, commonsensical. And it's going to be, it's going to reflect what I do, a representative of the people. And so it's going to represent.
But it is fair to require that it shouldn't prejudice the process.
No, I mean, I'm careful about that.
All right.
I mean, by my training, I'm careful about prejudice when the case is being looked at, especially by no meaner person than the Chief Justice. But I'm going to start from a remote area. Now, I have held a position that our Constitution needs review. I've heard calls for a constitutional review, and I agree with those calls. But I've often said that our problem as a country is not more with the text of our Constitution than it is with the people that we put in office. It's not more with the text than it is with the people we put in office, the attitude of the people we put in office. Look, some of the inadequacies of our Constitution has come to light more of late because the government in power, with His Excellency the President, have sought to push the text of the Constitution to, in some cases, absurd limits. And that is why people are raising their voices more than ever before that there's a need for a constitutional review. Morality counts in the application of law. The morals of the people in charge is supreme. Look, we have never had a ceiling as to how many ministers a president can appoint, for example. But no president has ever so abused it like now. And so it doesn't matter how well you draft the text. If you put a person who doesn't have restraint in power, you are going to have another situation. Look, and I'm making this point because there are 3 appointments that His Excellency the President made that I thought, by all standards, with good governance in mind, with the aim of building and strengthening institutions, he would not have considered. The appointment of Madam Jean Mensah to the Electoral Commission. For me, any well-meaning person would not have considered her, not because she's not qualified, but because of the history of that institution, given the way Charlotte Osei was removed, the basis upon which she was removed, and the attitude of Madam Jean Mensah running IEA and her long conflicts with some political parties. I mean, if you wanted a person
the political
to go without a baggage,
always aggrieved with somebody or the next.
I'm not talking about
IEA was doing a very good job, and I think they do. And Jean Mensah was leading that, even making sure pioneering, draft legislation for.
Samson,
for good
we are all
governance.
entitled to our opinions. That's your opinion of the IEA. I'm saying that.
Let's try and stay here.
If you pardon me, like I said, I'm not doing legalistic. I'm doing, my assessment of the issues as I understand it. And I'm saying that I will get to this matter, but that's why I sought your permission to start from a remote area. Look, the IEA may have been doing well, but it's also on record that the IEA, when Madam Jean Mensah was leading it, constantly was at loggerheads with the NDC. Constantly. That's something you can deny. Fairly or not,
when the
that
NDC
is
was
a
in
fact.
opposition.
No, even when it was in government. I mean, when the IEA pushed for biometric registration, the NDC was in government. So I'm saying that constantly.
The NDC was part of many IEA meetings, agreeing on a lot of things and roadmaps and legislations that they mooted. So
I'm not saying they never agreed with the IEA.
Right.
I'm just saying that constantly,
right,
it was in the news that they constantly had running battles with her at the IEA. It's in there. I mean, we all used to cover those stories. They were constantly in disagreement with her. So I'm saying that if I were the president and I wanted to build an independent institution and bring about some credibility around an institution like the Electoral Commission after Madam Charlotte Osei removal, I would not have put in somebody there that have had the history of, being at loggerheads with the major opposition. That's the first appointment I have issues with. The second appointment was Kisi Ejabin. And I'm not going to go into the details. He's a fantastic lawyer. He's a great, young man with a lot of prospects in the profession that he does. I mean, he has engaged in. But there are certain reasons that if I were in the president's position, I would have looked at, and for that reason, maybe I would have looked for another equally qualified young person to be in that position. Now, the third one was Mr. Martin Amidu. And during Mr. Martin Amidu's vetting, I made it clear why I was opposed to Mr. Martin Amidu. And you can still go online and read my reasons why I was opposed to Mr. Martin Amidu. And he has vindicated me all along.
So like Amidu, you have opposed Kissi Ejabing's appointment from day one?
From day one.
Okay.
Not because he's not qualified, not because I don't think he's an intelligent person who is capable of handling the position, but I'm saying that when you are a leader in charge of a nation that is so polarized, and you are minded about building institutions that can engender the support and confidence of Ghanaians from all walks of life, you'll be very careful about the people you pick to lead those institutions.
Amidu opposed Ejabing day one. What are your reasons for this, that Ejabing shouldn't have been the one?
Like I'm saying, there are some of the issues I'll not go into. Mr. Martin Amidu has raised some of them in a way that I disagree with. But you see, because he has been appointed and he's now in charge of that body, in my view, they have become moot. They are really not issues that we should discuss anymore.
I'm saying that going into the substantive.
Yes, I'm getting there. So I'm saying that because of the attitude of the president, we have some of these problems that we are having. He has appointed people to positions that perhaps he should not have, appointed them into those positions. And maybe he had
the
a
public will ask, for example, who at all is it that the president would have appointed that you will be happy with as an NDC MP?
I'm not talking about, you see, it shouldn't be reduced to me. It doesn't matter if I disagree with the person. But you see, my disagreement, the basis of my disagreement should not be something you can discount. I mean, for example, if I tell you that, look, because Madam Jane Mensah was always at loggerheads with the NDC, I don't think she should have been at the should have been the umpire or the referee.
President Akufo-Addo.
Yes.
As candidate.
It's something you can't disagree with.
Boycotted Jane Mensah's political debates, presidential debates. Boycotted it.
Yeah.
So that's also an issue.
No,
but let's go.
But not because of IEA, not because of Jane Mensah, but because of the conduct of people who were at the first one that he attended. He said so.
So let's move on.
His problem was not with IEA. His problem was with Kojo Opong, unfortunately, or fortunately, who has become his appointee now. So let's separate the facts. I mean, there are nuances to it, but if you generalize this, you miss the point that I'm making. Now, I'm saying that if you look at these appointments from day one, they sought to create these problems that we are having to discuss today. Mr. Martin Amidu was seen as someone who had fallen out, with the NDC, and so was like the bulldog set to go after NDC appointees. And unfortunately, he went into the office and perhaps didn't live up to the expectation of the president because he had his own mind as he went in there, and then they fell out.
The enemy of your enemy is my friend.
Became exactly, sort of. And I believe that is what informed the president's decision to appoint Mr. Martin Amidu there. And not, the president, I don't think, was really informed by, his decision was not informed by the conviction to build an institution that we could all trust.
I hope you are not trying to belittle Martin Amidu's stature as we have known over the years.
You see, if you look at Mr. Martin Amidu's petition now, today, clearly, he's judging Kissi Ejabing based on his standard. Mm-hmm. So he gives examples, for example, when I was there and this, his standard is poor. I'm sorry. He's somebody who has done so much for this country, but he has also done very, very poor things and terrible things. And so he cannot be judging his predecessor based on his standard.
Kissi is not above the law. Kissi is not above the law.
I'll get there.
There are circumstances and evidences of wrongdoing. He should be dealt with.
Yes. I'm saying that his standard, Mr. Martin Amidu's standard, is not the one we should use to judge Kissi Ejabing's performance. Because Mr. Martin Amidu's standard, in my view, was that bad and low. And in his petition, he seems to be suggesting that his standard was the best standard, and that is the way Kissi should have proceeded. And that, again, in my view, is typical Martin Amidu for you. just as he left the Attorney General office and felt that any other Attorney General who took over, fell below his standard, he is doing the same thing in this case. And I'm saying that, look, if we are minded to assess people who have taken over from him by his standard, then we will not be going, forward as a country. And that is why I rather will want to discuss the alacrity with which the president has acted on this petition. I mean, yes, it may be based on different provisions of the Constitution, but the operative word is shall. That when the president receives a petition, he shall forward same to either the Chief Justice or the Council of State, as the case may be, for action to be taken. And in the past, when the president received a petition involving Madam Charlotte Osei, the argument, because I'm not a lawyer and I listen to the lawyers, the argument made at the time was that the president had to automatically transmit the petition to the Chief Justice. And I had issues with that because my common sense couldn't accept that. I didn't understand why the president would have made a poster boy for any petitioner.
He's just a conveyor belt.
I couldn't understand that. I thought that the framers of the Constitution had a motive, making the president the recipient of a petition.
Because he's the appointer.
Yeah, but you see, he should be a gatekeeper of a sort, in my view. That is what I thought. But the lawyers educated us otherwise and said he was supposed to just be a conveyor belt.
Correct.
I disagreed with that commonsensically. But legally, I grant the lawyers who are trained to interpret these things.
Because he has no duty, he has no business in the process.
But even with my difficulty with the explanation that was given, the legal explanation that was given, I was expecting that on that note, any other petition that the president received would be treated the same way. That it is, you see, things must be logical, so as for not to, assume bias or assume ill motive. So if the president acted in that manner when Charlotte Osei was petitioned against, I expected that when Jean Mensah is petitioned against, I'll get the same attitude from the president. But it's on record that the president has been petitioned not once and not by one person, but two people at least I know, two different petitions that I know of against Madam Jean Mensah. And the president has not as much as even acknowledged the petition being sent to him. And so you begin to wonder, what makes the president act? Is it when the petition is in sync with his agenda? Or is he really a law-abiding president who has sworn by the Constitution to uphold the Constitution of Ghana? Clearly, with the two examples, the latter is the case. It seems he acts only when the petition is in line with his agenda. And that is why some of us are
But
of
as
the...
I noted,
Yes.
this one, so you in Parliament decided that since presidents want to abuse the constitutional provision, Article 146, which simply says you receive it and you forward, and it doesn't give timelines. We know that good people can even make bad constitutions good.
Yeah.
But presidents have abused this. So you decided that for the OSP Act, let's put timelines there and force the president to forward it within 7 days. The CJ is forced under compulsion to determine within 30 days. The committee that will sit should not also sit forever. They have 14 days within which to bring their decision.
90 days, I think, section 55.
90 days, thank you very much. 90 days to make their decision. So this is it. This is an improvement on that provision. So in this case, you can't make that comparison.
Well, again, I'm not a lawyer, but I'm sure you agree with me as you educate us that an act does not, overthrow a constitutional provision. It may clarify it, it may enhance it, but once the Constitution says, and my issue really is not with what the president has done by forwarding this. My issue is with why he has not done same in all cases. I'm not challenging the president for doing what he has done. Yes, he is going by the dictates of Act 959.
Right, Section 15.
Section 15 of Act 959. But I'm saying that we also have Article 146, is that it?
Yes.
And we also have petitions that have been sent under Article 146. And he is minded to act on an act of parliament. How come he's lackadaisical? He's pussyfooting. When it
Presidents generally have abused Article 146 because when the petition
the generality of the abuse doesn't make it unquestionable.
Yeah, all right.
The generality of the abuse doesn't mean we shouldn't question it.
All right.
So the point I'm making is that I think that the problem is with the attitude of the president. Even before we go into the merit or otherwise of Mr. Martin Amidu's claims, I think that we are faced with this problem because we have a president who is regime-centered more than he is concerned about the building of a state that should have institutions such as the Special Prosecutor Office to help in the fight against corruption.
Okay.
His commitment to the fight against corruption by all intents and purposes, and the things he has done in the past and the things he's doing now clearly show that it's zero. He's not just committed to the fight against corruption. He is interested in...
He passed this
act,
which is a most effective way to fight corruption.
Is it?
He is the one who eventually ensured that the Right to Information Act was passed, which is another great move to bring sunshine, which we say is the best disinfectant. Professor Kwapong, thank you very much for joining us.
But Samson, the
from
RTI
a good governance angle.
It's not about passing these laws. Because these laws, in fact, I'm sure they were drafted and they were pushed long before he became president.
20 years.
Yes. So if they were passed, we will expect a certain level of commitment when it comes to its implementation.
You're right about that.
The RTI
you're
law,
right about that.
Only recently, when the
Sweeney, let's
okay, so I'll let you proceed at least.
So you see,
agree with me
when I
on
make that, if you're familiar with me as one of the lead campaigners for the RTI Act, you will know that I have stated without any equivocation that the RTI law was ripe and was about to be passed by the NDC government in 2016.
Absolutely.
But the NPP, because you had delayed, the NPP shut it down because they wanted to take the praise for it. And they have done it. So whatever the situation, they did it. Yes, Dr. Kwapong, thank you very much. I know that you will look at these matters from a governance, good governance angle, as the CDD will always do to assist us. How do we look at this?
Thank you, Samson, and good morning to everyone else. So after going through and reading through the petition, if you recall last November, after the Special Prosecutor held that press conference, we discussed it on Newsfile, and I took exception to the way he addressed the judiciary. And I recall saying that it is not every time that you would get the outcome that you want from a given institution, and that when you don't get it, it doesn't necessarily mean that the institution has conspired against you or it's trying to undermine the work that you're trying to do, right? And so that was the issue that I had back then in the way he described some of the decisions that had been made by, I think he made reference to some 4 specific cases. I was also concerned at that time, and still remain concerned, that we are also currently in an environment of deepening mistrust in our key institutions of governance. And so when certain voices speak in certain manner, it only further erodes that trust and compounds the issue. However, from a governance perspective, as to whether this rises to an impeachable offense is where I draw the line, right? So Mr. Martin Amidu has every right to point to certain things and use that as a basis as to why he doesn't think the special prosecutor has to remain in office. But as I look at some of the bases, I keep asking myself, do these rise to the level of, an impeachable offense and for which he must be removed from office? As Prof. Abochi said, the standard is it has to be stated behavior and, incompetence. But what really is stated misbehavior? In the US, we have the same fight over an impeachment provision which says high crimes and other misdemeanors. And the sort of conventional wisdom is that, well, high crimes and other misdemeanors as an impeachable offense is what a majority of the House of Representatives say it is. But you don't want it to be that loosely defined, right? That you want some parameters around it where we can look at it and say, yes, this is really stated misbehavior. And hopefully that is what the process would arrive at. But except for maybe the procurement, breaches, if proving, these other issues, I'm not sure from a governance perspective, rises to the level for which you must remove the special prosecutor from office. For example, the issue of the abuse of citizens' rights. From all of the cases that have followed, I don't recall the special prosecutor not granting any of these accused persons due process. Yes, the fight against corruption is one that can't be, fought gently. So maybe his approach may have been, aggressive, whatever you may want to describe it, but still, it was geared towards ensuring that, these cases are prosecuted to the extent as possible and make a determination as to whether corruption or other corruption-related offenses have been committed.
You say whether they are issues that should get to that point, even if they were found to be so. Are you joining those, and I'll be bringing Amanda in on that as we try to wrap up on this discussion. Are you joining those whose argument is that, well, if it is about procurement breaches, the procurement law tells you what to do when there's a procurement breach. And we have a classic example in front of us now, SML. They attempted twice to get approval for a certain procurement. They didn't get it, and they went ahead. Later, they got ratification. That's one of the ways of curing a procurement breach, ratification. If his comments about judges and judicial decisions are against the ethics of the profession as a lawyer, the question people ask is, why not drag him to the disciplinary council like all lawyers face or attorneys will face? If it is that the comments were contemptuous of courts, like Martin Amidu suggested in his articles, then we know what to do when people have acted contemptuously. They are cited for contempt before court. It is not about dismissing them from office. And then finally, if it is about a refusal to grant you an RTI request, the RTI law is very clear. There are 2 windows of appeal and a final opportunity for you to take a suit in the courts to challenge the denial. Is that where you are, that if this is what they are, that is the approach and not a dismissal, an attempt to remove him from office?
Yes, because there are other ways of remedying these infractions. It doesn't mean that removal from office can't be one of the possible remedies. But as I read through them and as you have outlined them, for me, to remove the special prosecutor from office and not to downplay some of these issues, I would think that it has to be egregious enough, right? That, everybody should be able to look at it and say, okay, as for this one, he went too far, he went overboard, he's not fit for office, this is just scandalous, etc., etc. But if there are other administrative remedies that can be used to resolve some of these things, then you don't want it to rise to this level of, let's remove him from office. That for me is my opinion, that if there are other remedies, why not resort to them? Why go first for remove him from office? And we are talking of a law that has been operational for only a couple of years. First special prosecutor leaves, second one, who knows what the outcome is going to be. For me, it doesn't also set a good precedent for the fight against corruption, and it deepens the already eroding public confidence in the fight against corruption. I always have to cite something from Afrobarometer. But if you look at the most recent Afrobarometer, the perceptions of institutional corruption is growing. The confidence in the fight against corruption is sharp declining. And so when you have such a central figure in the institution as part of that fight against corruption, all of a sudden being the one, and don't get me wrong, we must hold public officials accountable, but it just seemed to reinforce this public perception that maybe we are really not committed to this fight against corruption. And that is also very, 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 very worrying. It undermines the confidence that we have overall in our commitment to good governance.
You say if this were to be very egregious, then you can elevate it to a removal rather than other disciplinary processes. We were all very livid, were we not, that the special prosecutor was dealing with Professor Frimpong Boateng, someone who was helping the state and helping all of us in this manner, the manner he has tried to do. The special prosecutor was dealing with Asoma Hene, a member of the Council of State. He was dealing with Cecilia Dapa, a minister who has had to resign. And, Colonel Damoy and the rest of them, customs. And if he says that he's breaching their rights in the manner he arrests them, how egregious do you want it to get before you elevate it to something for removal from office?
But Samson, in all of the cases that you cite, and if I recall very correctly, due process was also granted them. I don't recall that in any of these cases he either arbitrarily, arrested them, or the search of Madam Cecilia Dapa's property, he did it without a warrant or without seeking the necessary administrative procedures to be able to do that. If for anything at all the things that he has brought against these individuals, they have also had an opportunity to respond to him by challenging some of these decisions.
And they have been successful in some of the decisions anyway.
Precisely. So at the end of the day, he's gone about his work the way he saw it fit. But at the same time, the citizens have also been able to, quote unquote, respond appropriately based on the rights that are granted to them as well. So I don't see that doesn't rise to the level of this egregiousness that I'm talking about.
Okay.
If he had acted arbitrarily in the way he treated them, then yes.
All right. I'll take just very brief remarks, then we take a break and return to look at the Cedi. The Cedi. Atuforsen has such a sharp jab for Dr. Bawumia. He says he should stop the offbeat dancing and take care of the Cedi. That is also dancing to 15 cedis to $1. So Amanda, what are we saying? That this shouldn't happen, and in your article you say this is a slippery slope. He should never, ever, be removed. How do you say that?
Well, I think I'll qualify my article by saying that obviously because the Office of the Special Prosecution is an independent office that has been set up to fight the hardest crime you can fight within Africa, which is corrupt acts by officials that, need to be prosecuted, the standard is very high. And Mr. Amidu's petition simply, on the face of it, prima facie, does not meet that standard on any level, because this is about misbehavior or incompetence. And as the gentleman just said just now, it's about, just a sort of this high standard or other misdemeanors. Do you see what I mean? High crimes.
The Cecilia Dapa matter, for example.
Yes.
There's a group that is petitioning Parliament to look into it.
Yes.
Do you hear some of the claims they make? They are saying that it looks like there is a cover-up, an attempt by all the institutions that are dealing with it to let the woman go. And that OSP did its bit. And that they are actually pointing us to, they say there are over 20 statements that OSP interviewed the people involved, Cecilia Dapa and her family. That one of them, a cousin, had actually said she was carrying, 200,000 US dollars or so. And that money, because you have to declare, this is what she did. That's what she has put in a statement before the Office of Special Prosecutor. Mm-hmm. And that Oyoko should have paid attention to it. That she said that money, what she did was that when she was getting on the plane, she gave as many people as she could, 10,000 each. Because if it's 10,000, you don't declare, right?
Up to 10,000, yes.
Yes. So she gave as many people as she could find, 10,000 each, so that when they got to Ghana, then they gave the money back to her. That's how the source of that money.
Yes.
They say
that's the definition of money laundering in itself, I think, to circumvent the process.
So Martin may have a point somewhere.
Well, I mean, the ultimate point is that the Office of the Special Prosecutor has been set up for such investigation, and they did their job according to Section 3 of the Office of the Special Prosecution Act, which includes investigating and prosecuting cases of alleged or suspected corruption, which happened in the case of Dapa and Professor Boateng. So, again, he was acting within his job, and if we start persecuting the second Special Prosecutor to the extent that the standard, in my opinion, has not been met in terms of misbehavior or incompetence, of high crimes and other misdemeanors, etc., with this petition. And so if we remove him, it means the office itself will be politicized, and every future person that goes into the Office of the Special Prosecutor will be persecuted potentially in such a way, whichever government there is. So I do think it's very good that the Chief Justice has invited the Special Prosecutor to comment before she decides if the prima facie case exists, because prima facie means that the petition is viewed as correct unless proven differently. So he would have to answer to 6 of these claims, and in his capacity as Special Prosecutor, say why he pursued that and why that was not misbehavior or incompetence. And so his actual written statements can be considered by the Chief Justice, and if she still doesn't think it's satisfied, she can send that to a committee to review for 90 days. But it's a slippery slope that I don't think that we should take.
In the politics of it, just a minute, in the politics of it, you're beginning to hear all sorts of, like you will always hear when these things happen. And in the reports, that's when this matter came up, when the media was reporting it, you hear that there was a demand on him to resign earlier, sometime last year. And it appears that when he declined, it's like, at all costs, we'll get you down. And also the suggestion is, he's going after our people. In case we don't win power, we are dead. Let's get him out and bring somebody in now. And when a person comes in now who, is one who is ready to play ball with us, who's a party person, they will not prosecute us.
And that is why the Office of the Special Prosecution has been set up, because, I know some of our previous Attorney Generals, for instance, were very offhand in going after certain people because, they felt as if as soon as they are out of power, they would be, they would go after them too. And so that is why Offices of the Special Prosecution has been set up, because the function is to investigate and prosecute cases of alleged or suspected corruption. And if this office is to maintain its independence, then we cannot get rid of the special prosecutor based on Mr. Midu's petition, which I do not believe is so outrageous. For instance, was it found to be $10 million in his bank account, in a Swiss account, related to a particular minister, etc.? That is glaring, for instance.
Okay. All right, thank you very much,
impeachment,
Amanda Clinton.
basically.
A minute comments, then we take a break.
Wow.
We come to talk about the Cedi.
That's going to be difficult to do in a minute. But I will try and summarize what I said earlier without introducing any new things because of the time. The point has to be made that my estimation of things is that Mr. Martin Amidu is seeking to judge Mr. Kisi Ejabin by his standard, and unfortunately his standard is not the best, and perhaps he has to be told so, and we all have to appreciate it as a fact. The removal, like you have also indicated, in my view, is far-fetched, especially if you look at the issues that he has raised. There are issues that have other means of addressing them, and so it is far-fetched. Apart from the fact that, except this is part of the agenda of the government, to remove anyone who, is not seen to be playing ball with them in the fight against corruption. And Mr. Dumolevo, experience comes to mind. The fact that he was forced to proceed on leave when only recently we have heard about what happened in GRA, and asking people's age was a matter of national security that had to be protected. So I am sad, however, that Mr. Martin Amidu seemed to be lending himself, to this agenda of removing people who seem to be acting independent of government control, especially because he was a victim, or at least he made us believe that he was a victim of the same, grand scheme by this government.
He's in a place you can trust that he is doing something genuinely, and not like people are saying that it is hate, it is jealousy, something he couldn't do, this guy is doing it. This is the man who left that office and
Martin,
used unprintable words on the president.
That's why
serpent of corruption.
That's why I'm saying that I am disappointed that no matter how well-intentioned this agenda is, I'm disappointed that it has given the president, who over the period has proven to be very, active when it comes to cutting people to size, people who stand in his way to size. I am disappointed that no matter how well-intentioned Martin's agenda is, it has given this president the opportunity to do what he has done to others who have decided to act in office independent of his control. I am disappointed that this is feeding into that agenda. And I can give you several examples of people who in this government have tried to act independently of his control and how they have all, suffered the consequences. I think that Mr. Martin Amidu should have been more reflective of his, his actions. And I'm sure if he did that, he would have realized that some of the things he once addressed could have actually been addressed without giving the president this, blank check to dismiss the special prosecutor that he is uncomfortable with. And I don't think that the request by the Chief Justice, in my view, is also out of place. I mean, again, I'm not a lawyer, but I don't think that if
it actually provides fairness.
If the case is that you look at a petition and determine whether it is worth, looking into, I don't know why you want additional material. In this case, not even from the petitioner, but from the accused. To make up your mind on it. So I am of the view that it is enough for the Chief Justice to look at it and, for example, write back to the president and say, look, this does not establish prima facie case, because if it is about procurement breaches, there's a way to deal with it. And so go through that route and deal with it. If it is about
what she was doing was actually inviting him, because, for instance, he's hired people from Yoko, etc. So what was your reasoning, and how does it support the office of the president that you recruited at that level? And so that is going into his mind, his mens rea, and then putting that in the report.
How much, premium do you place on that when it comes to removing someone from office?
Well, it shouldn't even be a ground.
That is why, in my view, the Chief Justice has enough information based on the petition forwarded to her to take a decision on this. But to request that, do you expect Kissi Jabin to go and give evidence that will be used against him?
All right. Okay.
So I don't think that it is a necessary request to make of the special prosecutor.
Thank you, Alasan Suhini and Amanda Clinton. Thank you so very much, Dr. Osai Kwapong, and also Professor Kofi Abochi. And we can all be patient. The president was to forward it within 7 days. He has done so. The CJ was to and is required to make a prima facie determination within 30 days. And then within 14 days, she's required to set up the committee of 3, and the committee of 3 has 90 days to bring their decision. After which, the president, once again, his job is only ministerial. It's a conveyor belt. Just convey the information. This is what the committee says.
So Samson,
if a prima facie is
made, convey all the petitions, like the one against the former Chief Justice?
Thank you very much. We take a break. We'll be right back to find out if the Cedi can be re-arrested.
The duty and mandate of the courts is to apply and enforce the laws of the Republic, and not to grant persons immunity from criminal investigations and prosecution. A court cannot injunct the OSP from investigating or prosecuting any person. The decision to investigate and prosecute lies with the investigation and prosecution authorities, such as the OSP, and the OSP has at all material times carried out its power to investigate with candor and professionalism, being minded of the rights of suspects under its investigation. It is also of the utmost importance that the judiciary should not interfere with investigation and prosecution authorities in respect of matters which are within their statutory powers. It will be gravely inimical to public policy, the fight against corruption, and the administration of justice if the court stepped into this arena to decide who should be investigated, who should be prosecuted, and who should not. That is not the function of adjudication. I do not intend to sound as though I'm predicting doom, but we are facing doom, and this is it. When I was sworn in, and in my life, when I take on the reins to do something, I do it to the best of my ability. They say I'm a
offbeat dancing on the campaign trail and focus on the dancing city. There's a lot awaiting our country as a result of reckless mismanagement by Alhaji Bawumia's government. Ladies and gentlemen of the press, you recall that when the NDC government was exiting power in December 2016, under the leadership of then President John Mahama, the cedi was trading at 3 cedis 80 pesos to $1, compared to the current 14 cedi 95 pesos as at to the US dollars as at yesterday. And I'm hearing that today the cedi is trading at $1 is trading at 15.05 as at today. Shockingly, but not surprisingly, the vice president, who doubles as the chair of the government economic management team, Alhaji Bawumia, has told Africa Watch that the cedi has performed better under his supervision. This is a palpable lie, of course. Statements such as this from Alhaji Bawumia have significantly damaged his reputation, as many people treat them with contempt it deserves, or at best, comic relief. Many businesses and households have questioned the voodoo conclusions of Alhaji Bawumia on the fall of the Ghana cedi on his watch. How is Alhaji Bawumia able to look Ghanaians in the face and claim that the exchange rate of 14 cedis 95 pesos to $1 in 2024 is better than the 2016 year-end 3 Cedi, 80 pesos to $1.
Ghanaian workers and their families are grappling with high cost of living and inflation of over 25%. Exchange rate of the cedi is now almost 14 cedis, if not more, to $1, compared to about 4 in 2016. That means workers who earned monthly salary of 1,000 Ghana cedis in 2016 were taking home the equivalent of $250. Today, 1,000 Ghana cedis is only $71. The depreciation of the cedi at this monumental scale, that is about 250% depreciation, represents a huge decline in living standards of Ghanaians generally and workers in particular. This is so because of our over-reliance on imported goods such as medicines, refined petroleum products, and food, whose prices are directly affected by the exchange rate of the Ghana cedi.
Right. I guess for this next segment, Godfred A. Bokwing, Professor of Finance and Economist, University of Ghana, Dr. Kwabena Otu, Chief Economist and Director, Labor Research and Policy Institute, Trades Union Congress, Charles Kusiapia Kubi is Head, Business and Economic Bureau of GUTA, and the Member of Parliament for Tamale North, Alasan Suini, is still here with us. And as I bring them on, you have some messages. I'll try and share them in the next batch. And the show is brought to you by Bank of Africa, strongest a group and closest a partner, MTN, everywhere you go. Ashasi University, educating ethical and entrepreneurial leaders for Africa. Robert & Sons Optical Services, your comprehensive eye care service provider for 33 plus years. My Way Insurance, dial star 165 hash on MTN to join My Way today. Syntex tanks, it's strong, it's tough, and Flamingo paints, simply superior. So let's begin with Suhini here. And so what's the point of the press conference? People know that the cedi has taken flights and people can feel what they feel. So if you organize a press conference and you simply repeat the fact that the economic hardship is worsening, what have you done?
Well, Samson, there are two ways to deal with a nation in crisis. One is to, as a leader, show empathy if you are unable to resolve the challenge immediately. And the other is to give a direction to the people as to how you are working to get them out of the problem. So two ways. You either show empathy or you give a direction and rally everybody around the way to get out of the problem. Unfortunately, in our circumstance, what we have is offbeat dancing. You go online and you see the chairman of the economic management team. And mind you, we are discussing economy. And it's because of the mismanagement and clueless handling of the economy that people are in the state that they are in. And yet you go online, social media, and the first thing that hits you is an offbeat dancing economic management committee chairman. And it's as if what is at stake is not about businesses collapsing. It's not about people struggling to keep body and soul together. But what is at stake is an election to win. It's as if that is the only thing at stake. It's an election to win, not a nation to build, not jobs to save, not businesses to save, not an economy in distress to salvage. And I wish I could provide a context to this discussion, Samson. I'll try, but because of time, I may skip some of the things. Our economy faced challenges between 2014, 2015, 2016, thereabout. As a result of a single spine salary structure that we introduced, that was considered to be revenue neutral, but didn't turn out to be so. Worse, we had an energy crisis. An energy crisis that was due to three challenges: debt in the energy sector, low generation capacity, and unsustainable supply of fuel. These three challenges led to an energy crisis coupled with the introduction of the single spine. Single spine, by the way, that led to the doubling of salaries of many public workers. Then we also had the tumbling of commodity prices around that time. And so the economy was hit so bad that the Cedi started moving from 2 cedis thereabout to about 3.84 cedis. And we're all alarmed as a country. In fact, I remember a man of God preaching with alarm that the Cedi was almost hitting 5. And that was unthinkable. Fast forward. By 2016, the triple challenge that created the energy crisis were resolved. The fuel was resolved through the fast tracking of Ghana gas coming on stream. The generation capacity was resolved by bringing in Ameri and the other plants,
to the point of having excess capacity.
To the point of having excess capacity. And then the debt situation was also handled by the introduction of ESLA. That was supposed to generate revenue every month for the settlement of these debts. And so the single spine effect was somewhat neutralized. And then we created, a fiscal space for the government to begin to raise revenue from the bond markets and others. So the EIU in 2016 predicted that government of Ghana's GDP was going to grow by about 8% in 2017. This prediction was in 2016. And so in 2017, a new government took over and perhaps sustained these hard work and gains that had been made. And so we posted about 8%, and then they sustained the gains. But guess what? They stopped the investments and the hard work that led to that prediction in 2016. And so the signs started showing on the wall. They went on a debt binge, accumulating debts and celebrating with kenke parties. And the debt is the core of our problem today. Any economist will tell you. They moved it from about 120 billion to almost 600 billion.
There was a banking crisis, and they needed to find 25 billion that was not contemplated to pay for.
That's for another discussion. But their approach to dealing with the banking crisis has been proven not to be the only approach they could have used. And perhaps if they had used another approach, the cost would have been better. And that is where the cluelessness of their approach comes in. If they had used a better approach, maybe we would not have had to spend as much as we spent and still ended up collapsing businesses and creating unemployment as a result of the approach that they use. So, like I was saying, they binge on that. They were clueless about the excesses that they inherited and even stopped contributing to some of the buffers that were created. And as a minority then, we kept ringing the bell, the alarm bells. But it was not obvious then for everybody to see. and then COVID hit. Look, this government had the best goodwill ever. Even under COVID, the revenue that came to them, in my view, wouldn't have even been realized if we didn't have COVID. So it was actually a blessing in disguise. If you look at it in terms of how much money was at the disposal of this government. And mind you, this government also have had the opportunity of being one that has raised the most tax revenue from the people of Ghana with little complaint. How many demonstrations have you seen on the streets against government increment in taxes? And yet,
so we're getting to the end of your presentation.
Yes, and yet they have been able to raise almost 300 billion tax revenue in the last couple of years. So, to whom much is given, much is expected. And so we did not, as a country, have any business getting to a point where our debt levels become unsustainable and we are unable to pay them as things stand today. We have had to endure multiple haircuts. As things stand now, we are not even paying our external debt, and yet we are unable to manage the stability of our cedi. And so it is as a result of this reckless management, and that is why the minority had to remind the people of Ghana again that, look, we rang the alarm bells earlier, they didn't listen, and unfortunately, we are in this mess, and they don't seem to even recognize the mess that we are in, and are not suggesting ways to deal with it. Rather, what the things they are doing are making things worse, and that's why the minority leader pointed to the off-budget expenditure that they are engaged in. That is further bringing pressure to bear on the cedi.
Go to the Chief Economist and Director, Labour Research and Policy Institute of the Trades Union Congress, the blunt-speaking Dr. Kwabena Nyarko Otu. And Doc, I've just been asking Suhini, and he repeats the complaints. We have heard the TUC speak about the difficulties, the clear issues of businesses, leaving the country and so on. Should it be a period of just making complaints? Please unmute your mic.
Okay, thank you, Samson, for having me. And I think this is an important conversation. But before I go into the cedi thing, I want to place on record that the single spine was not the cause of any of the economic crisis that we have had. Single spine today, the average salary on it today is about 2,500 Ghana cedis. It was much less when it was introduced some 14 years ago. But I leave that for another discussion. And we need to be a little bit more dispassionate about the causes or the recurring challenges that we face. The workers of Ghana are too hard-pressed to be blamed for any economic crisis. Samson, on the cedi, I recall the discussion we had almost 2 years ago about the cedi depreciation. And for me, the unnecessary reaction from the Bank of Ghana at the time, particularly issuing a statement attributing certain things to me, certain statements I've made on the program. I thought it was unnecessary because they should focus on the bigger picture and not focus on individuals expressing their views and frustrations about the cedi depreciation and its impact on Ghanaians. Again, I also made I made this recollection to remind you and listeners that, Samson, you have had too many discussions about the cedi. It means that it has become a recurring problem. It is. And I'm not sure we will have anything new to say about the cedi and its depreciation. Okay. It boils down simply to the structure of the economy we have. The structure we spoke about eloquently in 2016, the Gordgesberg economy. So you have an economic structure of production, export, and an external payment regime that essentially put pressure on the city. So the most important productive sectors of this economy are in foreign hands, gold and oil. So you realize that when we export, we actually are able to achieve a trade surplus. But then developments in the capital account, where we have allowed the foreign companies to repatriate large sums of dollars, means that the trade balance is overwhelmed by developments in the capital account, and the Cedi will continue to depreciate. So the Secretary General on May 1st talks about our excessive import. It is one aspect of it. We are importing nearly everything. Then the little dollar that comes in is also in the hands of foreigners. When you are in an economic crisis such as this, you need to leverage on your resources, and in our case, the natural resources. But for a very long time, we have placed those natural resources in the hands of foreigners. And it's in their interest to repatriate those things. And we should not forget that the exchange rate is simply a price. So there's a price we are paying for the excessive demand of dollars or any of the other international major currencies. And we are demanding it to import goods that we could conveniently produce here. So the underlying causes we all know, and there's very little new that anybody can say. But then come back to your question. Is anybody listening? We have complained a lot. And it seems to me that those at the helm think that they have their own solutions, and that solution isn't working for Ghanaians. Now, Samson, if you talk about the depreciation today and its impact on workers, it is disastrous. Prices are increasing on a daily basis. Meanwhile, the wage is fixed at a particular point in time. Okay. For the businesses, I mean, I pity them. But they are able, on a daily basis, to change their prices to reflect the changes in the exchange rate of the imported materials. How do workers How do workers respond? They respond by just using their static, stable salaries to meet the changing prices the businesses are offering on the market. Okay. So I agree with you. Probably we should move beyond the talking. Okay. But even before we move, I think that this economy has been in crisis for many years. Okay. I mean, once in a while, things come to a head. Okay. Like 2 years ago, when the depreciation became very rapid over a short period of time, then we talk about it. But in between the 2 years, there has been depreciation. And so I find it difficult that we talk of crisis only at a particular point in time. There's crisis in our households. There's crisis at the domestic production front. Businesses are not able to surmount the rising cost of production and all that. And probably what we need to be doing at this point in time, and as part of the talking, is to be able to have a national economic forum, not just once, but every year, for all of us to agree that the excessive import is hurting this economy. We should patronize. For all of us to agree that we need to do something about the external payment regime that we have so over-liberalized, and people can transfer any amount of dollars out of Ghana. For all of us to agree that something 2 years ago, when we were talking about this, one of the issues we spoke about is the way we have allowed our currency to be traded openly, informally, across, in front of police stations. You have people standing there around the airport roundabout, trading in the currency. The Bank of Ghana did something about it briefly, and those people disappeared. Today, they are back on the street. We need some consistency in tackling the challenges, not this upbeat one-off attempt that we do. And then if our suggestions are not being heard, are not being taken on board, probably as unions and as civil society organizations, we should do what unions do. We need to power pressure on the managers of the economy, not just these managers, the future managers that will come, to make sure that they do the right things for the people of Ghana.
Import substitution, you have stated over and again, is one of the surest ways to prop up, not just prop up the economy, I mean, or do so in a manner that is sustainable. 1D, 1F was brought in. So what are we doing wrong that we still can't seem to resolve the problem, even in the face of bringing in programs like that?
Okay. So it's amazing that we are launching factories and industries, but the import bill keeps rising. Okay. So what we are doing wrong, in my view, is that we are not actively supporting a domestic production sector. Okay. We are not doing that. The Americans do that. Look at Biden and his buy made in America. Look at the Chinese. Look at everybody is doing that. But we have something here we call the import lobby. Okay, so not long ago, the radio stations and television stations that were promoting buy made in Ghana rice were threatened by the import lobby, and they stopped. So this morning, for example, I heard on another network that there's an excess of domestic rice on our market, but nobody is buying them. And we are still consuming large amount of rice that have been stored in silos for decades. Okay, the import lobby is strong, and we are in the political season. They are actually funding political parties and will surely dominate the policy discussion after the political season is over. We are doing something not right. Our cost of production domestically is too high. Our infrastructure is too weak. Now, when you are at this stage and level of development, you need a special program to support and, I dare say, to protect domestic production. Unfortunately, we are not doing any of those things.
In the meantime, how are your members, coping and surviving these really, really telling times?
It's, as people say, Ghanaian workers are magicians. It's really terrible for not just our members, for ordinary Ghanaians.
That's right.
Everybody. Our members earn a salary. It is so woefully inadequate, okay, to confront the changing prices that we see on a daily basis in our market. But you should also remember that there are just so many Ghanaians that do not earn any regular incomes, and they are having a hard time putting body and soul together. And this is the more reason why we need a national conversation going, a serious non-partisan conversation about how we arrest the fall of the city, about how we produce domestically, about how we encourage Ghanaians to buy made in Ghana, but about how we also use policy to limit import, to support domestic production, to support the businesses that are doing their best, but they are suffocating under the unsustainable competition that we have introduced them to.
All right, Dr. Kwabena Nyako Otu, Chief Economist and Director, Labor Research and Policy Institute, Trades Union Congress. It's a pleasure always talking to you. Looking forward to speak to you very soon. Thank you very much. Now let me bring on Charles Kusi Appiah Kubi, who is Head Business and Economic Bureau of GUTA, the Ghana Union of Traders Association, right? Charles, thanks for making time to join us. Please unmute your mic. Hello, Mr. Appiah Kubi. Please unmute your mic.
Okay.
Great. We have you.
Hello, can you hear me?
Thank you very much. Thank you very much. And Professor Bokpin, hold on there for me. I want you to hear all of these people, and then we come to you to wrap it up nicely. Now, clearly, we know that businesses are suffocating and so on. But how bad is the situation? Hello, Charles. Okay, just a bit of a problem there. Let's.
Can you hear me?
Go ahead.
Can you hear me now?
Please go ahead.
Good. You're asking how bad there's no words to describe the situation we find ourselves in. And anytime we talk about forest hiking, there are three risks that we are exposed to as businesses. We are looking at economic exposure risks, transaction risks, and translation risks. So I'll take my time to give you an idea how we are losing out as businesses. We started the dollar from January around 11 cities, 90 pesos. And today, dollar is hovering around 15 cities to the city. So a typical example, if my working capital is $100,000 that I used to import, that means that any part of this January, I need about 1.190 million Ghana cedis to import. Today, as we speak, I need about 1.5 million Ghana cedis to import same value of items. I've been doing that. So you do the subtraction, I need extra 310,000 Ghana cedis to do that. This translates to capital depletion because I will need an extra 310,000 to support what I have to meet the same 100,000 Ghana cedis. So when you look at the depreciation of Cedi from January up to date, we've lost almost about 26% of our working capital. As if that is enough. When you're able to import, our CIF is indexed in dollar. GRA will tell you is convertible currency. But it must be benchmarked to the current dollar rates. That, of course, also add to the cost of importing. As businesses, when we are doing our cost structure, we factor all these things to it. So obviously, prices of items obviously go high. And you ask yourself the question, if I'm able to even pass on the cost to the consumer, do they have the purchasing power to meet that? Hello?
Yes, go ahead.
Good. You ask yourself the question, do the consuming public have the purchasing power to meet such extra costs that are passed on to them? And the answer is no. So what happens to us? You have stock, but there's no sales. And mind you, most of us are running our business on debt. That is, we're taking facility from the bank. Now, disposable income of the consumer have been depleted by inflation. They don't have the purchasing power. They can't buy. How do I make revenue to pay for my retiring debts with the bank? How do I pay my salaries? How do I make my statutory obligation with GRA? I can't. And this is staring at our faces. You see, from 2022, when we experienced similar issue, lots of businesses lost over 50% and more of their working capital. And some businesses have been collapsed. They couldn't come back to the market again. And day in and day out, we've seen businesses falling out. So I talk about what you call the transaction exposure as a risk. You see, when you see your capital depleted as businesses, it becomes a worry to you. So you probably want to have an option of moving out from the market. But where are you going? You have no other option. That is how I can probably describe the situation we find ourselves in. It's so scary.
Are there any means that as Guta you are adopting to interact with the government and leaders of the economy to find some ways around this?
Differently, yes. We've done severally, as one of your guests suggested. There'll be more engagement, but is that the policymakers or the managers of the economy are not ready to listen to your options? So we obviously will be having this kind of conversation every day, every now and then. The point is, let's look at the structure of the economy. Unfortunately, our economy are in the hands of foreign hands. We don't have control of what happens here. When we look at the FDI laws that favors foreign companies in terms of repatriation of equities and profits, without any introduction of retention policy to ensure that whatever you gain in this country, there must be a certain portion retained to run your operations. Let me give you a typical example. We've discussed about the GIPC law that established equity registration with solely foreign companies that want to trade in Ghana. They need about $1 million to do that, and that comes with property, plant, and then equipment. So you look at the component of it, you realize that people have made the $1 million, but real cash will be less than 20% of what they have raised as $1 million. So we'll pick foreign companies who want to export. And you look at their import values, it's more than even the $1 million they have raised as the equity registration. So the X, where did they get it from? That means that they have recourse to the little that we have reserved as a country to support local businesses. So we have told them that, wait, looking at the dynamics in the economy, can we engage our foreign partners or FDIs to say that now, bring the corresponding value of the imports you want to engage in Ghana. So you pick like the China Mall. If you know that every month you do $10 million, bring same corresponding value into the country.
Tell me this in a minute so that we can move on to Professor Bokping to try and find some other solutions. How much hope do you have, if any at all, that the Cedi's flights will be arrested, it will come back down and make things a little easier for you?
You see, forest highs is influenced basically by speculations and sometimes expectations. So it is the responsibility of the managers of the economy to manage information when it comes to speculation, so that they can reinvest some kind of confidence into the system. Now, people are buying forests, but not for transaction purposes, but for speculation that the city will keep on depreciating. So as a way of safeguarding their investment, they will convert the city and keep it in the form of forest. So it is the responsibility of our managers to give us hope, and not just with tourists, but with evidence that we are taking this pragmatic steps 1, 2, 3 to resolve the issue, not on politics, but real issues to resolve and to revamp the business environment. Because one, if they're able to do that, we as Guja, we as the business people will support such a call.
All right.
But until they leave speculations to the hands of foreign people, we will continue to have the city depreciated, and no one will have hope in this economy.
All right. Thank you very much. Charles Kusi Apia-Kubi, Head Business and Economic Bureau of GUTA. And on that note, we take a quick break. We'll be right back with Dr. Professor Bokping. Godfred Bokping is Professor of Finance and Economist, University of Ghana. Prof, we have been at this for a very long time, and thanks for the scholarship and guidance that you continue to give all of us on these issues. But look in the crystal ball and tell us, how does end of this year look like?
Good morning, Samson, and good morning to our cherished listeners and viewers. Samson, why do you want me to be the one to say what it will look like end of this year? I think it doesn't look that good. I'm hoping that it doesn't have to get worse than what it is right now, because in its present state, it's unbearable. The difficulty is that, Samson, there's practically no shield when it comes to the pass-through of the depreciation to businesses and households. The impact is almost synchronous. Elsewhere, in some jurisdictions, the pass-through of exchange rate depreciation takes some lag. But because of the over-dependence on imports and the low local content in our economy, the exchange rate has almost immediate effect or impact on households and businesses. And there's practically no shield, okay? And there are no mitigating measures, right? And therefore, we are just exposed in the manner that it happens.
I don't understand that there's no shield and practically no mitigation measures or something of the sort. We were able to hold the dollar when it took a similar, flight. And we held it at 10, 11, thereabout for quite a while. So it is possible, Dr. Bawumia will say.
Yes, I do not disagree with that largely, but Samson, that for how long? And within those periods, you notice that part of our foreign exchange management has been going to the international capital markets to take dollars from euro bonds. And then also we support that with the syndicated cocoa loan. These are the two major inflows. Then some relative fiscal discipline. But Samson, as we speak right now, these two major inflows are all at risk. We've lost market access, right? So if you check, since 2007, with our first Eurobond issue, and even particularly as part of our revamped debt management strategy, inbuilt in that is going to the Eurobonds. So annually, we've been doing $2.53 billion from the Eurobond market to shore up our international reserves. Then we also get a syndicated cocoa loan. But from the third quarter of 2021, we lost market access, okay? Then also look at the other major inflows. Cocoa. Ghana is doing poorly now with cocoa production. Okay, so all of this put together actually putting some kind of our undermining confidence in the economy. And you see that also manifesting the negative sentiment that we see. But beyond that, Samson, part of why the Cedi is behaving the way it is also consistent with the latest IMF-supported program. Under the IMF-supported program, they favor flexible exchange rates, which in itself limits the ability of the central bank to intervene in the market and fight off the depreciation, okay, by burning it through our reserves. Now, at the time we signed up onto the IMF-supported program, in fact, December 2022, our international reserves on net basis had reached a precarious state. In fact, it was less than 3 weeks of import cover. Okay, so part of the IMF program is to build our international reserves to the level of 3 months of import cover by 2026. What that means is that it ties the hands of the central bank from coming onto the market to sell dollar, okay, on its own account in order to mediate or moderate the depreciation. They can't do that now. They can't do that now. Okay, so if we're not under an IMF program, probably in an election year, the central bank will not sit unconcerned and probably would want to fight it off and burn it through the reserves. But we have a mandate target within the IMF supported program to build our reserves. And bear in mind also the reserves that Bank of Ghana had a cocktail celebration over, right? This is so simply because we are not servicing our external debt, right? Coupons and the rest of them. So why are we in this situation? Others have spoken about the structural issues, the conjunctural issues, and the rest of them. But there are other current developments fueling this negative sentiment. Part of that is also the delay with the restructuring of our external debt. By now, we were hoping that Ghana would have passed the second review, which would have occasioned the release of the third tranche under the IMF-supported program. But because the country has not been able to secure the MOU, which is a condition precedent to IMF board approving the second review, there's that delay. And then again, the uncertainty with the external debt restructuring. So that vacuum, the market is reading a deeper meaning into that. And that is why you see the negative sentiment has gone up. And the understanding in the market is that negative news actually exert greater volatility in the market compared to positive news of the same magnitude. Somewhere April, the Ministry of Finance attempted to preempt this by coming out and telling the market that they had reached agreement with our external bilateral creditors. That was supposed to calm the market. Once you reach that, then it shouldn't take us that long for the IMF board to approve the second tranche, out of which we may get $360 million. Usually, if that had happened and we had a board approval, that positive news would have probably engineered some confidence in the economy. Okay, now we are missing out on that. The other bit we also need to bear in mind, Samson, is that it's an election year. Usually, election year comes with its own uncertainties, right? Okay, so we have all this happening together with an election year that promises to be a competitive one. When it happens that way, in terms of portfolio flows into the country, there's a slowdown, right? So foreign investors would usually adopt the attitude of wait and see, right? Less the election before they commit to any major investment or portfolio flows to the country. Apart from that, the residents, you and I, businesses, because of that uncertainty, they are likely not to take major decisions. They may not trade their FX. They will rather prefer to store the value, yes, as a way of managing the uncertainty. Now, so if you put all these things together, so once we are not trading our dollars, look, assuming we had confidence in this economy and people are willing to trade their dollars, even the bedroom economy, and we're able to mainstream that into the mainstream economy, you will see some relative stability. But right now, there's no confidence in the economy. Everybody is trying to protect their value. So once you are, for instance, if you have 1 million Ghana cedis right now, there are very limited opportunities, options available to you, and you don't want to keep it idle. Then your basic instinct will be preservation. Then you'll be looking at a currency that is more stable, and the cedi is not stable. Okay, so people are cashing it from that perspective. The other bit, from a more technical point of view, is that the foreign exchange market, we can segregate it into two components. The spot market, where if you need a dollar immediately or over 2 business days, you will go to the spot market. If you need a dollar in 3 months' time, in 6 months' time, you don't need to be in the spot market. You have to operate in the forward market. But our forward market is not working. Okay, it's so shallow. So even for people who need dollars in 3 months' time, in 6 months' time, are actively in the spot market, accumulating the dollars right now. And so what it means is that we're actually fast forwarding the pressure of 3 months to today. And when it happens that way, there's no way the cedi will be able to hold its own against the major trading currencies. Now, Samson, let's come home. In this country, we are okay to do everything wrong and expect the cedi alone to do the right thing. The cedi is the pulse of the economy.
All right.
The cedi is the pulse of the economy. So it doesn't misbehave on its own.
All right.
Right. So it's a reflection of some underlying weaknesses that we need to resolve, which we haven't done. And here we can even talk about the fundamentals of the economy. Look, Samson, we said it on this program. When we got the IMF program approved, actually yesterday was exactly 1 year. The 17th IMF supported program was approved on May 17th. That immediately delivered what we call the IMF honeymoon effect, some relative stability. And then we took credit for it and celebrated prematurely. We said, no, it is not a substitute for doing the right thing on the country.
That's right.
And we haven't done that. We haven't done that. Then we suddenly expect that the cedi will perform a magic and the rest of it. Doesn't happen that way. And
Prof,
look, we can go back to what Dr. Baumia said when he was in opposition.
Right.
If the fundamentals are weak, the exchange rate will
expose you.
Right. And let's ask whether the fundamentals have improved significantly. The answer is no.
Doc, thank you very much, as always, Professor Bokpin there. And I'm in red, and there are many of you who are asking why. It's because my University of Ghana mate and very good friend, Dr. John Kuma, is being laid to rest today. In the meantime, as you always know, my outfits are supplied by Konati Clothing, not this one. They are at Adenta Shopping Center, Adenta Down. You can get them on 0244 676732. 0244 676732. Konati Clothing. What you wear counts. Just get in touch with them. They'll give you the best that you need to look your best. The final minutes.
Yeah,
what do we have to say? Yeah.
You and others to express my heartfelt condolences to the family of the late John Kuma. He was a very, very good friend of mine as well. And I think he made a lot of impact in our political space, in our governance, given the short time that he got involved. And we can only pray that the good Lord will grant him a peaceful rest and grant the family the presence of mind to overcome the loss, even though I know it's going to be very difficult.
That's right.
Now, let me say that Dr. Kobna Nyako got me wrong. My intention when I made reference to a single spine was not to blame workers. It was just to highlight the fact that a big revenue handle, expenditure handle like that had been introduced without a corresponding revenue to government. And so it became a burden for government to do that balancing of neutralizing the impact on government revenue. Right. But it was a good thing, and I am sure that perhaps if we had even continued on the trajectory that we started, we would have started getting more benefits from that, introduction of the single spine. I still think that we haven't been able to match productivity that well to payments in this country, and that
the value of people's wealth and their incomes have been wiped out so much. And yet you're listening to Prof, you're listening to everybody else, and you're not getting
and you see, and that is the point about value. Look, I have done a basic explanation of this. If you had 380,000 Ghana cedis to trade with in 2016, your value of products or produce you could get abroad was $100,000 with 380,000 Ghana cedis. Today, with the same 380 Ghana cedis, you can't even get $30,000. That's a value of about $65,000 lost. And so if you were trading with 380,000 Ghana cedis, the value you have lost today is to the tune of over $600,000.
Thank you very much, and those of you in Parliament, keep watching
the situation
and holding our managers to account. Let's see how it gets. As I invited you earlier, join us tomorrow. Join me tomorrow at 2, and we'll be asking if the courts can give demolition orders and when is demolition lawful. Emmanuel Bright Atoko and Veronica Frimpong will be joining my weekly legal clinic. Join us to learn more. And these days, there have been some demolitions around the place. And let's see what is lawful and what is not. I'm Samson Lardy Anyenini. This has been Newsfile. Thank you. Have a good afternoon.